Good morning, everybody. I am from the great state of Florida, born and raised, so I never had to worry about changing my domicile. It's pretty easy. Dan Fitzgerald called me and said, "Rob, I need you to come down because we need you to blow their minds." I said, "Well, I have the topic just for you, which is the very new Florida Community Property Trust. It has only been in existence since July 1st of last year. And in my opinion, it's a big thing. It's a big deal. It's a game changer. It's something that all of you should pay close attention to. But before we get into the trust, we should talk about community property. What is it? And it's something that confuses a lot of people, attorneys, law school students, advisors. But basically, remember this. Community property is nothing more than a different property regime. It is the other property regime from what we're used to, which is common law property. When you have community property, it doesn't matter how the property is titled. All that matters is that the spouses in a community property state own an undivided 50% interest in anything. So if it's entitled in one spouse's name, it's both of their property. If you have joint with rights of survivorship property, tenancy by the entireties, these are common law concepts. They don't exist in community property because however it is, the spouses own it 50-50. So the big question is, why do we even care? We're not a community property state. Connecticut isn't a community property state. There's only 9 of them. The reason we care is because people are moving out of community property states. And I'll give you this example. I've been practicing for 22 years. And in my first 20 years of practice, I might have had 5 clients move from California to Florida. In the last 2 years, I've had about 10 clients move from California to Florida. So community property states, people are moving out. I don't know if you're seeing that in Connecticut, but we sure are seeing it in Florida. It's also important because you have to remember the entire world, except for the English states, are basically community property. So if you deal with international clients, it's very likely they're from a community property jurisdiction. We actually are the exceptions under property law. Common law is an English concept. The reason we have it, and I'm going to throw a big word at you, is the Visigoths. Thank you, Visigoths. They appeared around the 600s, and they settled in the areas that we now know of Spain and France, and they created a code. And this code established community property, and it basically was designed to protect the rights of women who really didn't have much property rights back then. And so that's why we have it. And if you look on this next slide, you'll notice a little kind of commonality. This is the United States. And you'll see all the pink states on this. These are the community property states. And their pattern is, you'll see they're in the southwest carrying up to the northwest. Well, guess what? That's where Spain and France were. And that's why they have those community property states. And you'll notice the one little outlier, Wisconsin, way over there in the middle of the state, they were the last community property state, and they did it by statute in 1986. So they're the newest of the community property states, maybe the last. But, it can be done. It doesn't have to be just based on, you were controlled by Spain or France. You also notice the orange states, and Connecticut is one of those orange states. And these states have this statutory law, which I'll kind of briefly talk about in a little bit, called the Uniform Disposition of Community Property Rights at Death Act. And these are states that are trying to deal with the fact that people move from a community property jurisdiction into a state like Connecticut. So you need to be aware of this because Connecticut, they've had that statute for, since the 80s. So the basic differences between community property law and common law states is title. I was talking to one of my partners, Court. He's talking about people moving into the state of Connecticut, and they had community property. And the question is, well, what is it when you come in to the state of Florida? Well, we really don't know. Some people say that the moment you cross the border, you change your domicile, like Dan was talking about, then the community property status ceases for assets that follow the couple to that new state. But regardless, whatever the situation is, common law property passes by title. That's all that matters. When you have that financial account titled in the name of the wife or the husband, that is their property. If you have real estate titled in their name, that is their property. But a community property, it does not matter what the title is. It does not matter. Now, the other thing that confuses a lot of people, because community property is confusing in and of itself, is it's not all the same thing. I showed you the 9 states that have community property. Well, their regime, every state is a little different. Now, there are some common things that they have, but the most common is that you have to be married to have community property. Now, you might notice my little asterisk there on that first bullet, and that's because there are 2 states where they've allowed community property for civil partnerships. Hawaii is one of those states. So you can have community property and not be married, but that's truly an exception. But the big differences from state to state is, well, if I have a community property asset, I'm married, is the income community property? Well, it depends. It depends upon which state you're in. Sometimes the income is separate property. Sometimes the income is community property. You need to know the jurisdiction that you're dealing with. The big thing is rights of creditors. Some states say that if you have community property, the creditor of one spouse can only go after half the property. But other states say that a creditor of one spouse can go after the entire property. That's a big deal if you have clients where one is a high liability spouse and the other is a low liability spouse. You need to know these factual questions. Now, community property is unique, and it's the reason why we have the Community Property Trust, because, and I'm going to kind of get into it with the Internal Revenue Code. If I see people falling asleep, that's okay. It is the code. But community property, you get a full step up in basis. You heard Rachel talking about basis earlier today. Well, upon the death of an individual, that individual's assets get a step up in cost basis. My professor, Calfee, from the University of Florida would have said, well, you can also get a step down in basis. People tend to overlook that, but usually assets appreciate. But for community property, everything gets stepped up, even the surviving spouse's assets. The other thing you have to worry about with community property is when you make gifts. If both spouses have a 50% ownership in the whole property, and they make a gift to a trust of which one of those spouses is the beneficiary, you've got a problem. You've made a self-settled gift. So you have to change that community property. We call it transmute it into separate property. So these are things that you need to think about. When you die or upon divorce, community property has to divide 50-50. So here's the code. So if you need to get some coffee, go ahead into the back. But let me describe why the Community Property Trust is important, because it comes right out of the Internal Revenue Code. And we start with these basis rules, which are under 1014. And 1014A establishes the general rule that when you receive property, you acquire property from a decedent, upon death, the basis of that property is its fair market value as of the date of death. And then 1014B establishes 10 situations where we treat it as being acquired from a decedent. And 1014B1, that's kind of the one that everybody knows about. If you acquire it there, you see by bequest, devise, or inheritance, you've got inherited property, you get your stepped up basis. 1014B3 is another common one. That's if you own it in a revocable trust, right? You're not acquiring that by bequest, devise, or inheritance because it's in a trust, but they say if the settlor has the right to revoke that, it's equivalent, therefore you get your stepped up basis. Aha, but now we go to the big one. This is 1014B6. This is the reason for Florida Community Property Trust. And you will see there that I have italicized, underlined, the difference between the other basis step up and this one. And that says, it will be treated as acquired from a decedent, property which represents the surviving spouse's 1/2 share of community property held by the decedent and the surviving spouse under the community property laws of any state. So if you call it community property, you make it community property, when the decedent spouse dies, the first spouse, the decedent spouse's assets get a step up, but because of 1014B6, so does the surviving spouse's assets. Now, why do we have this? And I would say this is one of the most confusing things about it. It was actually designed to be fair. In the 40s is when they created this statute, 1014B6, because what was the situation in the 40s? Usually, the husbands owned everything. And it was actually unfair to live in a community property state because the husbands often died first. And there's a reason for that. There's actually a medical reason for that. It's because they want to. But when those husbands died first, they owned basically everything, and everything got a full step up. But if you were in a community property state and the husband died first, you only got a 50% step up. So they were at a disadvantage. B6 was created to equalize it so that the spouses who don't have the title to the property still get the benefit of the basis step up. And that's why it was done. Now, it's kind of funny. Times have changed. Now, titles everywhere. Husband, wife, spouses, joint, it's all over the place. Now, this is something I've just included in the materials so that you have it, so you can refer to it later. This is the Uniform Disposition of Community Property Rights at Death Act. You know, us lawyers, we do not call it a decuprata. So, but what this is dealing with is essentially a constitutional issue. And that is, we've got Section 1 of the 14th Amendment that says, no state shall deprive any person of life, liberty, or property without due process of law. Well, if you change your domicile and everything's titled in one spouse's name and you move from California to Connecticut, well, guess what? The other spouse doesn't own anything. They just lost all that property, potentially. That's what this act is dealing with. It's saying, hey, you may not have community property, but you have the rights of community property. And notice the word rights is stuck in there because that's what's created. It's like pretend community property. Connecticut established it in 85, Florida followed in 92. I'm going to skip through the rest because the real action, the part to blow your minds, is the community property trust. Now, you will see that this is not new. We've had community property trust for some time. And Alaska was the first. Alaska always seems to be the first. You know, I think they have more caribou than people, but they're always ahead of the game. Now, Alaska's a little different. Alaska's elective community property regime allows you to create a trust, or you can do property outside of a trust and make it community property. Tennessee was the first to do it in 2010, where it's just in a trust. South Dakota followed in suit, and then Kentucky in 2020. And Florida is now the 5th state to do it. And it was my committee that worked on this to put this together over 4 to 5 years. We basically were looking at the Tennessee and South Dakota statutes to come up with this. Now, you will notice that there's mandatory provisions in all of these regimes. One is that both spouses have to sign the trust. It has to be signed by both spouses. They have to have a knowing thing that they're doing. But both spouses don't have to fund the trust. It can come from one spouse or the other. The trust has to make sure that it declares it's community property, and you have to have a qualified trustee, which essentially is a trustee who is located in that jurisdiction. And I'm going to get into that with the Florida. This is the big question right here. Will community property be respected by the IRS? We don't know the answer to that question. Okay, we don't know, but we think we know. Now, some would argue, and I would put the IRS in that category, that there's a case called the Harmon decision, where the United States Supreme Court said that they would not recognize an opt-in community property trust for purposes of splitting income. And it was focused on income. What was happening back in the 40s and 50s is spouses were trying to create community property to split the income to get lower tax consequences. And the United States Supreme Court said, you can't do that. You can't shift income by creating this trust. But the IRS in 1977 created a ruling, and it said, we'll let you do community property and elective community property for gift tax purposes, but you can't do it for income tax purposes. Remember that Supreme Court decision, Harmon? Not going to let you do it. So we feel like we fit right within Revenue Ruling 77, and we are outside of Harmon because Harmon focused under the letter of that decision, income taxes. We also have the language of 1014B6 itself. You read it. It says, under the community property laws of any state. So if a state, by legislative act, signed by a governor, creates a law, that is the law of the state. And I would argue that that is statutory and therefore should be controlling. We have no decisions. We do not know the answer to this, but I think it would work. I certainly think it's something to talk about with your clients. This is a slide that just shows you how the tax court reviewed jurisdictions to determine if there's community property. This is the one where you need to think about your clients and whether you think it's relevant. Number one, this is for long-term stable marriages. This doesn't have to be first marriages, but it has to be stable marriages. Earlier, Rachel was talking about the Brady Bunch. Mike and Carol Brady could do this. I think they'd be the perfect couple for something like that. With that house, Carol could have sold it right after Mike died and got the benefit of the full step up. Highly appreciated property. We have a lot of situations in Florida. Probably you have it in Connecticut, where you buy a residence, you hold that residence, your basis is $100,000, and now it's worth millions. That's a big capital gains event. And what happens when the first spouse dies? Often the surviving spouse wants to downsize. Well, if they sell that residence, they only got a half a step up in a common law jurisdiction. Community property trust, you'd get a full step up. Concentrated positions. Executives who get compensated in shares, so they have low to no basis shares in companies. This allows them to put in a community property trust, and upon the death of the first spouse, they could sell shares and avoid capital gains on that. So think about that. But the one downside are creditor issues. This is our Governor DeSantis signing the Community Property Trust Act. I did not get one of those pens. This is just a walk through the statute. These are the definitions. You've got the community property. The one thing Florida did is we specified in the statute itself that the income is also community property, because remember I said that's a difference between jurisdictions. And you have to have a qualified trustee. Now, if the spouses live in Florida, they could serve as the qualified trustee. Now, these are the things that you must do for a community property trust. It must declare that it's a community property trust. It must have a qualified trustee acting. It must be signed by both spouses. And it must have this really fancy disclaimer language on this slide. Now, you'll notice that this disclaimer language has to be in all caps. Now, for the benefit of this audience, I did not put this in all caps, so it would not be screaming at you in all caps. But my favorite part of this disclaimer language, because I had to spend a lot of time with the family law section in the state of Florida, me and my colleague, working on this language. And you'll notice there at the bottom it says, and this is something that they wanted added, you should seek competent and independent legal advice. Now, I can tell you that attorneys at Cummings and Lockwood are very competent. So we can satisfy that part of the provision. This must be in the document. These are very flexible. You can change things. You can do things. The only thing you can't change is upon death or divorce, it must be 50-50. There is no other way. It has to be 50-50. Pretty much everything else is customizable. It's by default a revocable trust. That's actually a difference from the other statutes. We decided to make it a revocable trust. You could make it irrevocable, but if you do, the surviving spouse still has the right to change their share upon death, because it's their interest, 50%. The community property does not have to be by residents of Florida. You could be a Connecticut resident, clients with Connecticut residents, and put intangible assets into a Florida community property trust as long as you satisfy those requirements. If it goes in as community property, like you have the couple moving from California and then they move out, it comes out as community property. So what comes in comes out the same way. And Florida, till death do us part, we decided to go with the 50-50 rule. So if one spouse has a creditor issue, then only half of that property is available to the creditors of that spouse, not the entire property. And so therefore, you need to make sure that if you have high liability spouses and you have a low liability spouse putting assets into this trust, then that's potentially a loss of 50% of those assets. 1507 is death, 1508 is divorce. This is my only statistic in the slide, and it is 100% accurate. And that is the same rule, 50-50, but it doesn't have to be 50% of every asset. You can slice and dice it however you wish. It doesn't have to be a pro rata. But what we did do, and this is from the family law section, the default is if there's real property or a business, they will not be co-owners of that. They wanted to kind of separate the couple from those situations. And it will not affect child support. Now, the hardest thing we had to do is family law attorneys, we have a concept called equitable distribution. Well, that's not 50-50. That's just whatever the court deems as equitable. That does not apply to a community property trust because it has to be 50-50. And so it's kind of like a post-nup because what comes in has to come out 50-50. If you put Florida Homestead into this, talk to your Cummings and Lockwood Florida attorney, because there are things that you have to do to make sure that you don't cause a problem upon the death of the first spouse. We have this constitutional issue. There's a restriction on devise. That's just a reminder. Don't just throw a homestead into a community property trust without good counsel. This is belt and suspenders. Hey, IRS, this is exactly what we're doing. This is a 1014B6 provision in this trust. This is Florida community property. And the last slide for my presentation, I like to call this the litigator's slide, because this is where the litigators get to sue as to whether that community property trust is going to hold up. Because if it were unconscionable, if it wasn't executed voluntarily, basically all the normal things that you would see in like a family law post-nup, prenup case, the attorneys can bring out here upon the death or divorce of spouses. So I hope I blew your minds. I hope you think about this. Thank you for your time.